One of the major functions of the ICAO is to gain adoption of the International Standards and Recommended Practices, SARPs, and incorporate these as annexes to the Convention on International Civil Aviation. There are now 18 of these annexes listed in the 1944 Convention, and they are constantly under review. This is to ensure that they remain relevant and applicable to modern-day civil aviation. You are required to be able to identify the ICAO annexes and their content. The 18 annexes are Annex 1, Personnel Licensing, Annex 2, Rules of the Air, Annex 3, Meteorological Services for International Air Navigation, Annex 4, Aeronautical Charts, Annex 5, Units of Measurement to be used in air and ground operations, Annex 6, Operation of Aircraft, Annex 7, Aircraft Nationality and Registration Marks, Annex 8, Airworthiness of Aircraft, Annex 9, Facilitation, Annex 10, Aeronautical Telecommunications, Annex 11, Air Traffic Services, Annex 12, Search and Rescue, Annex 13, Aircraft Accident Investigations, Annex 14, Aerodromes, Annex 15, Aeronautical Information Services, Annex 16, Environmental Protection, Annex 17, Security, Safeguarding International Aviation against Acts of Unlawful Interference, and Annex 18, the Safe Transport of Dangerous Goods by Air. In addition to these annexes, there are some other ICAO policy documents you must be aware of. Firstly, PANS OPS, Document 8168, the Procedures for Air Navigation and Aircraft Operations, or PANS OPS Document 8168, is a two-part publication. Volume 1 describes the operational procedures for air navigation, or PANS, that are recommended for the guidance of flight operations personnel. Volume 2 describes the procedures for the guidance of specialist personnel designing instrument flight charts in geographic areas requiring essential obstacle clearance. Secondly, PANS ATM, Document 4444, the Procedures for Air Navigation Air Traffic Management, or PANS ATM Document 4444, gives guidance to air traffic organizations on the procedures to use when controlling global international air traffic. And finally, the Regional Supplementary Procedures, Document 70304. This document has been developed to enable any geographic regional air navigational differences to procedures to be recorded. This would normally be done by the ICAO regional offices and approved by the Council. It should be noted that PANS are approved by the ICAO Council, whereas SARPs are adopted by the ICAO Council. The ICAO also publishes a wide variety of publications in the forms of circulars, pamphlets, manuals, and the ICAO Journal, which cover technical, economic, and legal subjects. It also issues training manuals, films, plans, and digests, all designed to inform the global aviation community. Here is a list again of the annexes and their titles, and the procedures documents that you must know to help you remember them. Two other important documents have been developed to accommodate the ICAO's desire to facilitate the exchange of commercial air transport rights. Not all signatories were originally able to agree to this desire, so two supplementary documents were created. These two supplementary agreements establish important international aviation. The first agreement, the International Air Services Transit Agreement, makes provision for aircraft of any participating state to fly over or land for technical reasons in the territory of any other participating state. The second agreement, the International Air Transport Agreement, further provided for the carriage of traffic between the state of registry of an aircraft and any other participating state. These two agreements establish 5 important freedoms, and in the remainder of this lesson we will examine the two documents in detail and in particular, the freedoms that are associated with them. The first agreement to discuss is the International Air Services Transit Agreement. The International Air Services Transit Agreement establishes two very important freedoms of the air. These first two freedoms are the first two of 5 freedoms, which together form the technical freedoms. In this context, the word freedom refers to a privilege conferred by virtue of a bilateral agreement. The very first freedom is a freedom to fly across the territory of another participating state without landing. The second freedom allows for a privilege to land in another participating state for non-traffic purposes, like refueling or repairing, but not for the uplift or discharge of passengers, cargo or mail. The International Air Transport Agreement establishes the third, fourth and fifth freedoms, collectively known as the commercial freedoms. The third freedom provides for putting down in a signatory state passengers, mail and cargo taken on in the state of registry. The fourth freedom provides the privilege to take on in one state passengers, mail and cargo destined for the state in which the airline is registered. The fifth freedom provides for an airline registered in one state and en route to or from that state to take on passengers, mail and cargo in a second state and put them down in a third state. Due to the growth in air transport and the evolution of airlines operating on a global basis in partnerships, further commercial freedoms have evolved. The modern freedoms provide the 6th, 7th, 8th and 9th freedoms. The 6th freedom provides the privilege for an airline registered in one state to take on passengers, mail and cargo in a second state, transport them via the state of registry, and put them down in a third participating state. The 7th freedom provides for an airline registered in one participating state to take on passengers, mail and cargo in a second participating state, and put them down in any other participating state, without the journey originating, stopping or terminating in the state of registry. The 8th freedom operates within the European Union and allows European Union states the ability to operate amongst the states of the European Union without constraint, no matter the state of registry. In effect, it allows cabotage. The 9th and final freedom was created as a direct result of a conference in Kuala Lumpur that allowed booking code sharing between airline operators. This allows a scheduled flight operator to fly passengers, mail and cargo on a route that has been allocated to another operator or one that is shared by other operators. Unlike the first 5 freedoms, freedoms 6 to 9 are informal in nature. That is, they are not the consequence of any formal international agreement. A number of security-related conventions and protocols have come into being to deal with the increasing global air transport security risks. 3 conventions and a supplementary protocol exist that institute measures to increase the security of air travel. Over the years they have been enhanced, and the 3 now form the basis of the ICAO security regulation. The Tokyo Convention of 1963 provides that the state of registry of an aircraft is competent to exercise jurisdiction over offences and acts committed on board signatory aircraft. In the case of an anticipated or actual unlawful seizure of an aircraft in flight by a person on board, then all states party to the convention are obliged to take all appropriate measures to restore and preserve control of the aircraft to its lawful commander. After a series of hijackings in the 1960s, the international community, under the auspices of ICAO, resolved to deter and suppress such terrorist acts. The Hague Convention of 1970 ensures that any such act should not go unpunished, and it defines the act of unlawful seizure of aircraft. The Montreal Convention of 1971 further amplified unlawful acts against the safety of civil aviation, and specifies those acts making them punishable by severe penalties. It is mainly concerned with acts other than those pertaining to the unlawful seizure of aircraft. The protocol supplementary to the Montreal Convention of 1971 was adopted in 1988 by the ICAO Conference and extends the definition of offences given in the 1971 Convention to include specific acts of violence at airports serving the civil aviation community. To provide international weight to these conventions, all contracting states have agreed to make the identified offences punishable by severe penalties. You will recall that Annex 17 of the ICAO Convention deals with security and requires signatory states to adopt the SARPs and establish security authorities, programs and mechanisms for determining threat levels. Of course, to make all of these conventions work, training programs are essential, and all signatory states are required to implement such programs and plans. Additionally, as an ongoing commitment to security, each state is required to cooperate with other states in the research and development of security systems and procedures which will better satisfy security objectives. The ICAO conventions allow any aircraft commander who has reasonable grounds the ability to restrain any party on board, and to protect the safety of the aircraft, persons or property on board, maintain good order on board, deliver or disembark any person to the competent authorities if he believes they are jeopardizing the aircraft. While the commander can demand help from a member of the crew, he or she can only request the aid of a passenger or other non-crew member. You should now understand that the protection of all aspects of international air transportation is a complex one and a constantly changing situation. The cooperation between signatory states to ensure that the highest standards of aviation security apply, whilst maintaining the advantages of the expeditious nature of air travel, is essential. Although most regulation has been defined and adopted by all states throughout ICAO, some states within their own regions have created separate additional layers of regulation, an example of which is the European Union, the EU. This lesson will therefore briefly mention the regulations and the governing bodies within Europe. The driving force for a common civil aviation policy across Europe is the European Civil Aviation Conference, ECAC. Set up in 1955 under the auspices of the EU and ICAO, its aim is to define a European approach to a general structure for civil aviation in Europe, licensing, safety, European regional air traffic control, and a structure for civil aviation marketing within Europe. Because of its established position within Europe, ECAC is able to be the forum for the consideration of major civil aviation topics relevant to all the European states. The Joint Aviation Authorities, JAA, is an associated body of the ECAC, representing the civil aviation regulatory authorities of a number of European states, who have agreed to cooperate in developing and implementing common safety regulatory standards and procedures. The JAA membership is based on signing the JAA Arrangements document, originally signed by the then current member states in Cyprus in 1990. The JAA's work began in 1970, and its original objectives were only to produce common certification codes for large aeroplanes and engines. From 1987, its work has been extended to operations, maintenance, personnel licensing, and certification and design standards for all classes of aircraft. With the adoption of new regulations in 2002 by the European Parliament and the Council of the European Union, a new regulatory framework was created under the European Aviation Safety Agency, EASA. This new agency of the European Union has subsumed the responsibilities of the Joint Aviation Authorities. EASA is the sole European regulatory and executive body concerning civil aviation. Presently, the JAA now only exists in a transitional phase to help liaise between EASA, and the civil aviation authorities of the non-EASA JAA member states. Eurocontrol was founded in 1960, with the objective of providing common air traffic services in the airspace of European states, the Single European Sky Initiative, and strengthening cooperation between members in the matter of air navigation. Today, it has a much wider remit, most notably in the field of air traffic flow management, which has led to the establishment of the Eurocontrol Central Flow Management Unit. In 1990, a harmonised licence for air traffic controllers in Europe was launched, when the ECAC transport ministers called for the development of guidelines for the training and licensing of air traffic staff in ECAC states. This work became part of the European Air Traffic Control Harmonisation and Integration Programme. As Europe as a whole continues to evolve and adapt, the European aviation community will also constantly change and evolve. So to stay fully abreast of the changes, make sure that you consult with your instructor regularly to stay fully up to date. A more recent ongoing development is the European Air Traffic Management Programme, which, through its ATM 2000+ initiative, will allow gate-to-gate clearances. That is, an air traffic control clearance all the way from the departure to the destination airport. In this lesson, we will very briefly examine the history and details of the Warsaw Convention and its associated documents with regard to carrier liabilities. In 1929, it was established that civil air transport carrier liabilities and responsibilities needed to be addressed, as international air transportation was beginning to boom. The Warsaw Convention started this process. Over the years, the articles of the Convention were improved on by the Hague, Warsaw and Montreal Protocols, which now mean that firm rules on carrier responsibility and liability have been established. The Warsaw Convention mandates carriers to issue passenger tickets, requires carriers to issue baggage checks for checked luggage, establishes the principle of absolute liability of the air carrier, and limits a carrier's liability to at most 100,000 special drawing rights, SDR, for death or personal injury, 17 special drawing rights per kilogram for cargo, and 1,000 special drawing rights for personal baggage. The liability values were originally given in points carrés francs, but this was amended at the Montreal Protocol to substitute the liability into special drawing rights. The value of a special drawing right is similar to a currency, and, much like a currency, its value varies over time. The approximate value of one special drawing right is £1 sterling. For an up-to-date value of the special drawing rights, please see the website of the International Monetary Fund, the IMF. As a result of the numerous emerging national airlines and operators during the previous century, there grew a wide variety of ticketing types and passenger and freight contracts. These proved very inefficient and were going against the harmonisation that ICAO had tried to set up. To resolve this, the International Air Transport Association, IATA, drew up an agreement between ICAO member states to have a common ticketing, post and freight carriage system that holds common international liabilities. The Multilateral Interline Traffic Agreement, MITA, forms the basis of the Multilateral Interline System, MIS. Some 300 operators now accept each other's tickets and airway bills, and thereby their passengers and cargo traffic, on a reciprocal basis. A standard format for tickets and waybills exists, and resolutions govern how they are produced. This also means that a passenger can fly complex routes all around the world in one transaction and in one currency. This multilateral system helps save the world airline travel market $3 billion and demonstrates the effectiveness of cooperative practices. As long ago as 1919, international meetings agreed that the rules of the sea would also apply to the air. So an aeroplane is regarded as carrying the same status as that of a ship. In practice, this means that the laws of any nation apply to an aeroplane whilst it is airborne over that nation or an international airspace. Over the airspace of another land, the laws of that land apply. The captain of the aeroplane is invested with the authority to uphold these laws. The laws of the state of registry therefore apply to aeroplanes in the same manner that they apply to ships at seas. It is further required that the operator nominate a captain from one of the fully qualified crew members to enforce the articles of Annex 6 to the Chicago Convention. Essentially, he is responsible for the operation and safety of the aircraft, and for the safety of all persons on board during flight time. Flight time being the period from brakes off to brakes on, or for helicopters, the period when the rotors are turning. Remember that the protocols to the Warsaw Convention are in place to counter the unlawful interference of an aeroplane and to counter the perpetration of unlawful acts on board. It is the duty of the aircraft captain to enforce this. The Operations Manual defines in Part 1 the duty and responsibilities which, by virtue of the validation of the Operations Manual by the authority, are confirmed as being that as required by national law. The Rome Convention of 1952 deals with the damage by foreign aircraft to third parties on the ground. The Convention endorses the concept of absolute liability of the aircraft operator for damage caused to third parties on the surface, but places a limitation on the amount of compensation. It also provides for compulsory recognition and execution of foreign judgments. During the 20th century, the global economy developed enormously, and many international trade alliances, free trade zones, and economic tariff barriers were set up. Whilst this was fine for the countries concerned, this led to some severe trade protectionism, which in turn severely restricted the growth of commercial air traffic enterprises. Added to this, the escalating costs of aircraft and fuel, and the monopolization of the major air routes by the large national carriers, led to a general inability of the smaller air carriers to flourish. To survive, smaller organizations turned to the leasing of aircraft to minimize their costs. This meant that the whole issue of liabilities, insurance and safety urgently needed addressing, and this was recognized by the ICAO as early as 1948. Through the Convention on the International Recognition of Rights in Aircraft. Leasing became defined as the situation whereby an aeroplane is used by one operator, whilst the ownership title remains with another operator. The following terminology is generally used with regard to the leasing of aircraft. Wet lease is when the leased aeroplane is operated under the Air Operator Certificate, AOC, of the lessor, the operator lending the aeroplane to the lessee. Dry lease is when the leased aeroplane is operated under the Air Operator Certificate of the lessee, the operator borrowing the aircraft. Leasing between JAA operators has become commonplace, together with the terms wet or dry lease out or in. Permission must be obtained from the regulatory authorities to undertake such leases. Leasing of aeroplanes at short notice is permitted to ensure that air transport obligations are met. It is a given that permission is approved, subject to the following conditions. The lessor holds an AOC issued by an ICAO state. The lease-in period does not exceed 5 consecutive days, and the authority is notified of the arrangement as soon as possible. The European Union, however, took the view that it needed to legislate for aircraft leasing arrangements independently of the international systems. EU signatories are bound by EC Council Regulation 2407/92, which contains all the provisions on leasing. Its declared aim is to harmonise policy to the highest possible degree. The World Trade Organization and the General Agreement on Trade in Services for Aviation, WTO, GATS, also establishes procedures that lead to the abolition of unfair practices and encourages growth in the global aviation economy. In 1948, the Council of the ICAO established Rights in Aircraft on Air Traffic, This relates to the international laws that concern ownership of aircraft and the rights of the lender or mortgagee, and recognises ownership and rights of possession.